All right, hello YouTube Live. Welcome to the channel. We are here and looking forward to seeing everybody. Let's see. All right, there we are. Want to make sure that everybody's had a chance to hop on. We are currently, let's see, this is early January, and our topic is all about what we can do when we are interested in increasing rents. I want to welcome all of you to today's YouTube Live. My name is Ernie Garcia. I am your landlord attorney, and I am here to get things going and make sure that everybody has an opportunity to get their questions in after I've given a little talk about rent increases and the kinds of things that I recommend when it comes to rent. Hello there. We want to welcome everybody as they come in. For those of you who are unfamiliar with our format, we do about a 10 or 15 minute lesson before we get into our Q&A, but then we have a Q&A session where either you can send me questions ahead of time or you can add your questions into the chat. Either way, we want to make sure that we have the ability to see what you guys are saying and add that in. Let's see. All right. Okay. Well, so we've got a few of you in here. Looking for my chat function. Give me a second, guys. I'll be right on this. Okay. There we are. And here we go. So today's topic, what are my rights and limits when it comes to raising that rent? I want to go ahead and get onto that in just a second, but I do want to talk again about the methods that you can join us if you are interested in participating with the chat. Again, you can get ahead of time and submit your questions to me either through joining our Facebook group, Texas Landlords. If you are a member of that group, every week we collect questions from the group members, or if you'd like to get on our mailing list, you'll see our phone number and our email address across the bottom of the screen here, and you are welcome to join us that way. We welcome hearing from you guys and look forward to whatever it is your questions are. I'll prepare those. But if you got a question that comes up during the chat, we welcome you to join us at that point. Yeah. Okay. So, all right. Well, we want to go ahead and get started then. We've got a number of viewers, and we want to go ahead and start off with our topic. So what are my rights and limits when it comes to increasing rent? Well, there's a few things that definitely you're going to want to consider. I want to go through 5 of those things because a lot of people are hesitant to raise rent. Some people kind of forget about the fact that costs go up and it becomes absolutely necessary to raise rent. And then you get into a pinch because, well, you don't want to lose your tenant because you have to raise rent. But if you don't raise rent, you might lose your house because your costs are going up. And now it's becoming increasingly more and more difficult to manage those costs. So the idea of rent increase isn't this greed factor. And you got to stop seeing it that way. The idea of rent increase is a natural progression in your business. As things progress, things are going to get more expensive. We live in a time and place where we know that costs have gone up in the last few years. But if your rent hasn't gone up, well, you're making less money, and it doesn't have to be that way. And so I want to talk about some effective ways for you to get ahead of it. And so the first thing we want to talk about is, well, what's in your lease? Because we know that the lease is your most powerful tool. And if you're talking about rent increases, you want to make sure that you're on the right side of your lease. And so by getting on the right side of your lease, you're going to be assured that you have the ability to do it, and then you've definitely got a point of reference in time. So I want to dispel any misunderstandings. The fact that you want to raise the rent doesn't mean that you necessarily can. If you're in the middle of a lease term, that rent is fixed. And until you come to an end of the term, you probably don't even have the authority to adjust the rent. And if you do have that authority, you want to make sure you follow the law. And so let me give you a few pieces of advice. So when it comes to a lease term, let's say you signed a lease in January and it doesn't end until December. Unless you and the tenant agree in writing to modify the rent amount, it's stuck. And so, a fixed rent is set and cannot be changed just because you decide you would like more rent. So make sure that if you're going to alter the rent, that you're at least coming to the end of the lease, or you have come to the end of the lease. And so, depending on what your lease says, you may have the ability, once your lease, for example, has lapsed into a month-to-month tenancy, to give your tenant written notice and then increase the rent. But just because you give notice doesn't mean you can increase rent in the middle of a lease term. You're going to have to come to the end, and you're going to have to give the proper amount of notice depending on what's in your lease so that your rent increase can be effective. So the terms in your lease are extremely important considerations when you're thinking about a potential rent increase. Okay, so all right, so the next consideration for you is there rent control? I know that some of you, come from different parts of the country and watch these videos, and you may be in a jurisdiction that does have rent control. If you're subject to rent control limits, you're going to have to know what it is your state or local jurisdiction say about your ability to increase the rent. In some jurisdictions, you're limited by a percentage. In some jurisdictions, you're limited by other factors. But if you have no limit, well, then it's open season. And in most jurisdictions, there is no upward limit. If there is one in your case, you're going to want to know what it is so that you stay within the bounds of the law. In Texas, there is no rent control. There is no limit to the amount that somebody can increase their rent. So it comes down to a business decision. What makes sense for your business, and without consideration of any specific amount or percentage. The business decision is completely up to the landlord in the state of Texas. And again, there are no limits here. If there are limits where you are, make sure you know what they are so that you're on the right side of the law. You don't want to get yourself in trouble by increasing rent because you presume there is no cap. If it turns out that you do have a rent control limitation, you want to make sure that you do increase your rent, but within that margin. So your next consideration, well, how much is too much? And I don't mean this in the sense that, there is some upper limit. Again, in many jurisdictions, there just isn't. But you have to consider, what you're risking and what you're gaining by increasing your rent by any amount. So, for example, we talked about the fear of losing a tenant based on an increase of rent. And that can happen. You may have a great tenant who's taking care of your property, but when you decide, after 5 or 6 years of not having raised the rent, to raise the rent because you absolutely have to, your insurance costs have gone up, your taxes have gone up, your maintenance fees have gone up, and so the rent has to come up. Well, that necessity might mean your great tenant can no longer afford to stay there. So, how much is too much? And so I want to give you a rule of thumb and not necessarily a hard and fast, you must do it this way. But if you're moving your rent up just with the rate of inflation, which right now hovers around 3 or 4%, and so if you decide, look, every year I'm going to raise my rent 5%, at least to keep up with inflation, then you're probably setting yourself up for an incremental increase that makes sense. Now, the problem with this might be that you're already 20% behind because you haven't raised your rent in a long time. This might mean that, you're going to have to lose your current tenant and then prepare for a new tenant and have your property set at a more proper market rate. And so, unfortunately, you're going to have some loss in that situation, but it might be for the better if it gets you to an earning capacity that matches what the market is otherwise requiring for your particular rental property. So, again, I don't want you to think of, too much of a rent increase as something that is, a specific amount. It's got to match both, what the market calls for in your area, as well as, what makes sense for your current tenant in place, and whether it makes more sense for you to pick something in the middle in order to keep a good tenant, or just decide I may have to cut ties with this tenant because I'm losing money in this setup because I just haven't raised my rent adequately over the past few years. And so your next thing to consider is, how often do you do this? My suggestion is that you raise your rent every 12 months. Every single year, you should be raising your rent some amount. And so if you're doing this, having set your rent at, in year 1, in accordance with the market, by year 2, if you're keeping that same tenant, the rent should go up again, approximately 5%. Let me give you a mathematical example. So if you've got rent, say at $1,000, a 5% increase is only $50, but you're going to want to increase it for that returning tenant, that $50, to account for that natural increase in the market. Because I assure you, if you wait 5 years before you increase the rent from $1,000 to $1,250, where it probably will be 5 years from now, as opposed to $50 each year until that year, well, you're setting yourself up for success by that slow incremental increase. 1 year it's $50. By the next year, it's another $50. So it's $1,100. And the year after that, it goes up to $1,150. And the year after that, $1,200. And the year after that, $1,250. So you're matching the market at all times. But that increase happens so slowly over the course of 5 years that the tenant doesn't feel it as drastically as if you did 1,000, 1,000, 1,000, 1,000, and then jumped up 25% suddenly to match the market, along with losing out on that increase, although paying it out in the rate of inflation and your rising costs throughout those years. Now you're losing a great tenant that you might have been able to keep, again, on that steady incline as you're making more money in response to, again, just the normal rate of inflation and the normal rise in costs having to do with your landlording business. So how often should you do it? I'm suggesting at least once a year. If you're waiting every 5 or 6 years, you're losing out on that gentle increase and those gains that you could have had in between rent increases. But if you do it gradually over time, you're likelier to make more money having done it. So the last thing is to use your rent increase as a possible defense. And this might sound strange, but sometimes you have a tenant who doesn't want to leave and is passionate about staying. And so let's say you're in a position where you have someone and they're paying $1,000 a month, and you decide, well, man, I'd really like to sell the property. I think this would be much more profitable if I sell it. And you're now on a month to month, and they absolutely will not go. And so you say, well, then I believe I'm going to raise the rent from $1,000 a month to $1,500. If you're that interested in staying, I believe I stand to make a more substantial gain by selling it. But if you're willing to pay this additional sum, this 50% markup, and again, this assumes you are in a jurisdiction that would allow a 50% markup, but you might say, as long as you're willing to pay, I'm fine keeping you here. Now, what you might find is that same tenant refuses to pay an increase, even though you have followed all of the requisite procedures to give proper notice and to wait until the end of the term and to make sure that your tenant has had an option to simply vacate because the original term came to an end. If you have fulfilled all of your duties as a good landlord, and that tenant has simply left, by raising the rent in an eviction matter, you can now demand the new rent rate based on the fact that you followed all the steps and you validly increased the rent for your rental property. This will likely speed up the eviction process and likely, prevent an appeal, or if there is an appeal or there is a judgment, it's set at the higher rate so that you're able to collect a maximum, a premium amount of rent from someone who's just become hostile and simply will not comply with your reasonable request for them to leave, or your reasonable request to pay rent at a higher rate because you're using the property in a different way. And it may be that you're having to adjust rent that drastically just to get back up to the market. A tenant who simply can't afford to pay the market rent, you can accommodate them to a certain degree, but also you're just not obligated to do it. And so you don't have to take a hit just because the tenant is no longer able to afford what the market requires out of your rent. And while that may sound harsh, again, if you are in the business of landlording, as opposed to just giving away free spaces or discount spaces where people live, then you take a more business-like approach when you're considering the need to increase rent and the viability of the amount of rent that you believe is necessary to match the market rate. So I hope all of this was helpful in establishing what makes sense when you're thinking about a rental increase and why it's important for you to do it, when to do it and to what extent, and then of course the procedure involved having to do with notice and having to give your tenant an adequate amount of time to respond to that rent increase. So let's go ahead and go to the comments. We have a few. Here, before we get into the prepared questions, I want to address a number of comments here by Nancy Wilson. There's no mention of inspection in my apartment lease. Back in December of last year, a property manager and someone from the city of Dallas showed up to my apartment to do an inspection. I refused. Well, if you have the long red, black and white form TAA lease, I am certain there is inspection language in that lease. But generally speaking, a landlord has a reasonable right to enter and a reasonable right to inspect as long as there is a valid basis. So I don't really know the facts. I don't have your lease in front of me, but I will continue. I refuse to let them in, Nancy continues, because nobody from the rental office told me that inspection was going to take place prior to them showing up. I'm not living in public housing. Was it wrong of me for not letting the property manager and the inspector from the city of Dallas into my apartment? The apartment complex is private property. My apartment lease ended January 7th, and I renewed my lease for another 12 months. There was a $10 rent increase. I'm on SSI. My former rent was $750. Thank you very much for having this live stream today. I'm learning so much from you. Well, you're very welcome. Again, if you sign that long form red, white, and black TAA lease, I guarantee you there's inspection language in that lease. However, if you're unclear, you might want to have your lease reviewed with a landlord attorney. We do this all the time for tenants. You might also ask your landlord for precisely what part of the lease, gives them the right to require that the tenant let them in for an inspection. A helpful landlord should be able to point out what provision in the lease requires an inspection. But if it really doesn't exist, then it comes down to whether or not the landlord had a reasonable right to enter. And if it comes down to the city requiring some inspection due to some health or safety matter, well, then that's probably reasonable. Now, how they went about doing it is also part of their reasonable right to enter. And without knowing a little bit more about what led up to that, it's difficult for me really to contribute much more than to say, take a good look at the lease. If you're unsure whether this exists, then it might be helpful to have that lease reviewed with a real estate professional who can guide you. Definitely someone who has familiarity with that lease. Again, that TAA lease, which is the most common lease for apartment complexes. If that's what you signed, I guarantee you there's an inspection provision in that document. So let's go ahead and move to the first of our prepared questions. Again, if you have any questions that you want to add to today's topic, we certainly welcome that. But we've got a set of questions that have been submitted to us ahead of time that I want to get to first and foremost. And here is our first one. Oops, we got a little formatting error. Here, what are your thoughts on security deposits, insurance instead of cash deposits? And what was in there was Rhino and Jetty. I'm not sure how the formatting got a little jacked up there. My apologies. But security deposits instead of, or security insurance instead of a cash deposit. Well, that's going to depend on the validity of the insurer. Sorry about that. Got a little thirsty. But, I don't know enough about these companies to know whether or not, you file an insurance claim and they're going to pay. I need to know more about the terms of payment and the amount of the payment and just what, is covered. So before I say that it is better or worse than a cash deposit, I'll tell you that in a lot of ways, by putting cash in your pocket and having cash and full control of it, at the very least, one of two things from your tenant. The first is, they've got the means to afford your rental space. So if they can pay a full month of deposit and a full month of first month's rent, I use that as a bellwether sign that this is a pretty good tenant. And if they're able to come up with that and then continue to pay rent on time, then again, it's a good indication that you found a good viable tenant. Now, it's not 100% guaranteed that they're going to continue to pay on time, but it's a really good first start. Certainly, if you require upfront first full month and security deposit and they can't do it, that's a red flag that you should take very, very seriously. But as far as these particular companies, I don't know enough about these insurance companies, nor have I heard enough about them in practice. I also am not familiar with their terms and what they expect in terms of, their coverage and the full extent of that coverage. So, I'm still on the fence because, I like the cash deposit method. I think it's an excellent way to, gauge, just how good a tenant is going to be, at least at the beginning. So that's me. And on that particular topic. Okay, so Jose Lira writes, thank you, Chuck, by the way, for contributing that question. Jose writes, I have a tenant who that has vacated the property, but left a lot of basic items, beds, couches, clothes, and dishes, and took all the appliances. Power and water has been cut off. What would be the process to clear the unit and re-rent it? I checked with HPD and the lady was detained and presently has an ICE hold. Well, unfortunately, sometimes people are just going to leave in the middle of the night. That does happen. And if it turns out you're in a situation where someone who, they've got an ongoing lease with you, it hasn't come to an end, but they have left and they have not continued to pay rent, and they took some of their stuff, but they've left most of it behind. Well, it sounds like you've got an abandonment issue. And so, hopefully your lease has an abandonment clause that you can use to, make sure that you can get rid of that stuff without any consequence. So, the abandonment clause in my lease is quite simple. It says, look, if in my reasonable opinion, it looks to me like you're gone, and if you are currently in default of your rent, which may or may not be the case here, but I would presume if they left and the utilities are off, they're probably in default. They haven't paid rent for the current month. If that's the case, and in my estimation, it looks like you've taken off because you took some of your stuff and I haven't seen you around, then the last thing I'm going to do is I'm going to send you a 48-hour notice. And I'm going to get in contact with you and say, look, you've got stuff here and it appears that you're gone. If I don't hear from you within the next 48 hours and you don't come within the next 48 hours and clear out the rest of this stuff, I'm going to consider everything here abandoned. I'm going to clear it out. I'm going to re-let the unit, and I'm going to assume possession. Let me know. And what I tend to recommend to landlords in this situation is, don't just send one text message. Contact this tenant in every possible way you know. Even send a letter to the rental property, because if they're forwarding their mail, they'll eventually get it. But you want to send a letter through the US mail, send them an email, send them a text, contact them on WhatsApp. Hopefully the notice provision in your lease has multiple avenues of getting a hold of them, including a work email and a personal email. And if it's a husband and wife, you got work email and personal email for both of them. Maybe it's a college kid and you've got mom's and dad's email as well. You want that notice to go out, and that way you can say, I went out of my way to notify them in accordance with my lease. And now that they're gone, I'm declaring all of this stuff abandoned. And I don't ever recommend going at 48 hours and 1 second into the unit and clearing everything out. But I would say, for example, if you sent a notice today, don't count today, count the next day and the day after that, and maybe 1 or 2 additional days, so that you can definitively say, I gave a reasonable amount of time. And so maybe in 4 or 5 days, you come back, you've heard nothing from them. It's the weekend. I'm going to go in, clear everything out, change the locks, and then prepare to re-let that property. I think that's a perfectly reasonable thing, but the best place to look is in your lease to make sure that you've got an established procedure that was agreed to between yourself and that tenant. So definitely always look to the lease for the most effective guidance on how to proceed. So let's see. Honestly, it's important for the city to take an inspection every year because some residents don't take care of the apartment and don't follow the rules of the property. Well, that's true. And that's true both in apartments and in single family homes. Nancy writes, I keep my apartment very clean, take trash out on a regular basis, keep roaches and other unwanted pests out. That's good. I never missed any rent payment back in 2025. Yeah, and again, it's still unclear what the basis of the inspection in your fact pattern was, Nancy. But again, I'm very curious about that lease and whether or not there is in fact a mechanism for inspection. So for now, let's move on to question number 3. Can you please confirm how rent pending appeal is calculated in a Texas eviction appeal for non-payment of rent? Specifically, I would like clarification on whether the court calculates rent payments from the date the appeal is filed or based on the regular lease due date, for example, the first of each month. So I want to make sure that this is clear so that everybody understands what's going on in this fact pattern. So it appears that someone has an active eviction, which has been appealed. So the court on the lower level has granted an eviction to a landlord, and now that tenant has filed an appeal. Well, whether you established rent in the lower court, whether you establish the fact of unpaid rent in the lower court or not, you should have had a determination of rent or rent value made in the lower court. This is actually a brand new element in the law that started January 1st, 2026. So that if you've established the rent or rent value, and I'll tell you the difference in just a second, then the court should set that as part of the judgment in the event of an appeal. Because if the tenant appeals, whether they owed rent or not, the rules require that now the tenant pay their rent into the court's registry for purposes of an appeal. And so what this prevents is those situations where a tenant has been sued for eviction because they had unauthorized occupants or damage to the property or an unauthorized pet. So this had nothing to do with rent, and they were current on their rent at the time the eviction was filed. But since the filing of the eviction, they have stopped paying rent, and now rent has become an issue. Well, in order to prevent that from, denying validly owed rent to the landlord, the courts now require, if you're going to appeal, you're going to pay your rent into the court's registry, and now the landlord has immediate access to those funds once they are received by the court. So generally speaking, when you've got a landlord-tenant matter, the issue of rent and the amount of rent is, again, an essential part of the lease. And so whatever that amount owed is understood or recorded by the justice court in that initial trial setting. So let's say, for example, today is the 14th. Let's say you go to trial today and the court establishes rent at $1,000. And so if a tenant files an appeal, they have 5 days to file an appeal, at least 6 days in Harris County. But so today is Wednesday the 14th. So they get Thursday, Friday, Saturday, Sunday, Monday, in most situations, is their last day. Again, Harris County, you get one extra day. But you get 5 days to file your appeal. Well, let's say they file an appeal and they file with an affidavit of inability to afford costs. Now, they filed this on Monday, the 19th. What the rule says is now, in order for them to stay within 5 days, they're going to have to pay at least 1 month of rent into the court registry. So that very first payment isn't due on the first of the month. It's due within 5 days of them filing this appeal. And so if they make that payment, they get to stay. Well, Monday the 19th is technically a holiday, so it wouldn't apply. And so if they filed it on Tuesday, that's the 20th. So they would have 5 days to pay: Wednesday, Thursday, Friday, Saturday, Sunday. You can't pay it on a Sunday. So they would have until Monday, the 26th of January to pay rent into the court's registry. But Ernie, what about February's rent? I'm glad you asked, because February's rent will now be due at the county court on the first of the month. Now, the rule does allow 5 additional days, but it does say you will continue to owe rent each month at the time rent is owed. So the first payment is subject to the date when the eviction appeal was filed, but each subsequent payment is based on the date that comes after that initial payment. Rent will continue to be due on the first day of each month after that initial payment due date. So, now this has nothing to do with back rent that may be owed, but definitely if there is continuing rent owed, it's owed in that way. Within 5 days of having filed the appeal, whether it's through a surety bond or an affidavit of inability to afford costs, they're going to have to pay rent within 5 days, and going forward, every first of the month thereafter in accordance with the lease. So that's how that works. If you need more clarification specific to your case facts, come see a real estate attorney. Okay, next we have question number 4 from Michael James. For the past 3 months, the tenant has consistently paid rent late. Before the end of the month, but without including the required late fees, this month the tenant is again late. She stated she would have the rent last week, but since then she has not answered my calls or returned my text messages. Today, I sent her a notice of default. If I do not receive a response or payment within the next few days, what steps should I take next? I want to ensure I am following the proper legal process. Well, that proper legal process has actually changed a little bit, and I don't know what notice you may have sent her last month, but if this is your first notice, that notice of default, well, that's not the same as a notice to vacate. And if you didn't send notices of default in each of the 3 prior months when you say she paid late, then the court may waive those rent delinquencies. Well, why is that important, Ernie? Well, because the law changed as of January 1st, 2026. If the tenant was not otherwise delinquent in the payment of rent in the previous month, and again, that's a fact issue because I don't know that you sent a notice of default for late or delinquent rent payment. In fact, the court may say it doesn't matter that it was late. What matters is whether you waived the lateness and accepted the rent without consequence. And your failure to give notice during those months seems to be indication that you did it without consequence. So what then of the current month? Well, what the law now requires in the current month, if in the previous month you cannot prove that the rent was in fact delinquent, then this month you have to give a notice to pay rent or vacate. So in this scenario, assuming that even as late as today, the 14th, the tenant still hasn't paid rent. I don't know what your notice of default says. I presume it just says, hey, you haven't paid rent. When are you going to pay rent? I'd really like for you to pay the rent. But let's assume she doesn't pay. Then you got to send a notice to pay rent or vacate. And let's say she elects to pay rent, say on January 24th, 10 days from today. Well, and it's within the time frame of your notice, right? You wait a few extra days, you give a 3-day notice to pay rent or vacate, and sure enough, on the 3rd day, she shows up with a full rent payment. Now, you're talking about late fees, and the eviction court, frankly, does not care about late fees. So what do? Well, stop tolerating late payment is the first thing you're going to want to do. Make sure that in February, when you get to February 2nd, you say, hey, rent was due on the 1st. I know the last time you paid me was January 24th. I was there, I recall. I did send you a notice indicating your delinquency. So now I'm just going to send you a straight 3-day notice to vacate and get rid of this tenant. This tenant is never going to catch up. If they keep paying rent like this, it's always going to be late. And so either you enforce the collection of late fees or you get rid of a bad tenant. Sure, you can apply the application of funds clause and do those sorts of things, but I don't know that you can repair the damage that has been done from a tenant who consistently pays rent late. You got to nip that in the bud the very first time it happens. Don't tolerate it because it doesn't get better. Especially if early on in the lease, they start off with late payment. That's a terrible sign. And the main way to correct it is either A, to anticipate it before it happens and let your tenant know, listen, if you haven't paid 100% of your rent by date X, I recommend day 7, but you can mark whatever day you want. If by day 7 you haven't paid 100% of your rent, I'm going to issue a notice to vacate. And that might be a notice to vacate or pay, but it's definitely going to be a notice to vacate. And so let them know that you're serious about the eviction process and you are willing and able to file that eviction should it come to it. And by getting ahead of it before it ever occurs, it's likely not to occur. And if it does, you got to make good on what you said, and you got to send the requisite notices, and then you got to file as needed if they fail to pay 100% of the rent. And if they're refusing to pay late fees, but they did pay the rent, well, if you've got an application of funds clause, you can let them know, look, at this point, you owed rent and late fees. I've applied your payments of late fees first. You continue to owe rent. Here's your notice of default. You still haven't paid the full amount. Here's a notice to vacate. Unless you pay the vacate or pay, unless you pay the full amount, you cannot stay and I will evict you. Again, you want to be serious about your notice. You want to be timely with your notices, and you want to hold your tenants to the requirements in their lease. All right, so here we go. Next question. Lily Gomez writes, we recently had some damage to the ceiling from condensation from the attic AC unit. Isn't that just a classic? Thankfully, no one was hurt when the chunk of sheetrock collapsed and the damage is being repaired. What do you recommend a new landlord do as far as protecting our assets? Should an injury ever happen? Besides insurance, is an LLC the best to have in place? If so, is that something your practice can help with? Yes, we can help you set up a single member LLC. If you need something more complicated than that, we'll likely refer you to a business law professional. But yes, we could help you set up that single member LLC because it is helpful, but less about protecting you from potential slip and fall cases, more from protecting your assets from each other. Let's say, for example, that you've got 3 rental properties and each one has 3 separate tenants and there's an incident in one. Well, if that rental property is owned and operated by Oak Street Rental LLC, and then you've got Elm Street Rental LLC, and then you've got Pine Street Rental LLC, well, those are technically all 3 different owners, and anything that happens on Oak Street doesn't affect Elm Street and doesn't affect Pine Street. Everything is separate from each other and therefore shielded from any liability from spilling over into the others. But if you own everything in your name, right? If Ernie Garcia owns property 1 and 2 and 3, well, then one claim out of one property could effectively wash out all 3. In fact, some claim that comes to me outside of my landlording business could come in and wipe out all of my rental properties. And so you definitely want protection from you against your rental business, and you're going to want protection from your rental business affecting you personally. And finally, you're going to want protection from each of your rental units affecting your other rental units. LLC designations are really, really good in that respect. Definitely insurance is good. Having a good, strong lease is also another area of protection that you should be incorporating. Don't just get whatever lease. Make sure that the lease that you have is a good lease. So a few tips for you to consider when it comes to protecting yourself from potential claims that do pop up. And whether it's injuries or whether it's mold or whether it's some other factor that you're being sued, you don't want any one lawsuit, again, to come and affect you personally or to affect your other rental properties. So, all right. Next question. Kim Cullens Cross writes, got a commercial tenant for 25 plus years without a new lease. So they were month to month, and they were given a 30-day notice since we are selling the property. They were very upset. We told them 2 years ago we were selling. We finally got an offer. They will not let us show the property. They have locked the doors even when they are there during business hours. I don't have a key. Can I have it rekeyed and provide them with a new key? I will not do it when they are there, as they are volatile. I do plan on giving them a key, not locking them out. Well, the part of this question that concerned me the most is the volatility of the tenant. I don't know why you're keeping them. I would certainly lock them out. I would prevent them from coming in unless they're paying rent. And so this might be that situation where you use your rent defensively. So let's say they've been there for 25 years, and let's say the current rent is $3,000. You might think about increasing the rent to $6,000 or $7,000 and use it defensively as a way to tell these people unequivocally, either you're going to pay to stay or it's time for you to go. Especially if they are getting in your way of selling your property. Can you get in there, switch the locks, hand them a key? Absolutely, you can. Can they just bar the door in some other way or change the locks themselves? Yeah, I mean, they physically can. They can't do it legally, and I'm presuming that your lease prohibits this and does allow you to enter for purposes of showing it to prospective landlords. Prospective buyers. But again, in this situation, if you're not going to lock them out, I think one way that you can definitively tell them, look, your time is coming to an end, is to give them a 30-day notice of rent increase. In this situation, again, I don't know what your rent is, but you could give them notice and then increase the rent to such a drastic amount that they're likely to say, fine, we're going to pack up and we're going to go. Or we're going to behave. And so that might also be a response that you get. Fine, we'll cooperate as long as we can stay a little bit longer on the current rent value. So think about that as an option because you've got this hostility. And if they simply won't see the reason, then give them that 30-day notice, increase the rent, and when they don't pay it, move forward with an eviction. That's really good. In fact, if you have a lockout right, if they don't pay the rent, you can probably send the requisite notices as required by your lease, and then just lock them out and prevent them from coming back. Somebody that hostile, that might be the only effective way of getting what you need out of your lease. So that's my suggestion. Hopefully things work out for you. Here is the last question. It's actually 3 questions that comes with a little bit of extra information that I'll go ahead and read for you because it is kind of interesting. So here we go. This is from Joy Stanchik. So it's been 6 months. I've been trying to get my tenants to sign a lease renewal. I would email, text, and call, and he would promise to sign, but he hasn't. Communication issues have always been my pain point with them. Now his voicemail and email boxes are full and he ignores my texts. Ooh, I've heard these facts so many times. I know he's alive because I see him on my Ring cameras. I think even if I reached him, he would promise again, but not follow through. He continues to pay rent, but refuses to use my portal. He tells me he loves my place and wants to stay. I want to know what my options are as far as asking them to leave, since there is no current lease. Well, there is a current lease, for sure. But I think they will likely hold over, and I may have to evict since the last lease he and his wife signed was July 24. I have 3 questions. So question number 1, will the court help me should I need to evict since I have allowed the lease to lapse for so long without getting them to renew? If what you mean is, will the court honor your eviction petition because you've let so much time pass with them on month to month? Absolutely they will. Remember, Texas, and I'm assuming you're in Texas, Texas does allow, and most states do, even oral leases, but you've got a written lease that is technically still in place. So this is a misunderstanding by a lot of landlords. They think, well, we don't have a lease anymore because it came to an end. Not true. The last lease that was signed by all the parties is still in effect. And so it's the controlling document, and you want to presume that it's still in effect because nothing else has been signed since. The only thing that's changed is that it's no longer within that original term. It is now month to month. And that's the way the laws in Texas regard that situation. Yes, the courts will honor it. Yes, that's the controlling document. And yes, you do have a written lease between you and them. It's the last one that you signed. Next question. Would the court care how hard I tried to get him to sign the lease, or is that not a factor in the decision? It is completely not a factor. Because it remains unsigned, it's an irrelevant document. It has no value because it was not part of some new agreement. The only way it would have value is if it were signed by all the parties as the new lease. Because it wasn't signed, the old lease is still in effect. So no, the court doesn't care how many times you tried. He's not obligated. Your tenant has zero obligation to sign a new lease. Now, consequently, and this is where my next answer is going to come, you have no obligation to him beyond this month-to-month tenancy. That's all you owe him as long as he keeps paying rent. So let's go on to your final question. Should I even bother trying to get them to sign a lease if I am at all considering ending it? Definitely not. I would at this point withdraw any lease that you have presented to him. Instead, I'm going to give you the same advice as the last question, and just send a 30-day notice of rent increase and drastically increase the rent. He wants to stay. He can only stay if he's willing to pay a drastically increased rate. I can almost guarantee you he'll beg you to sign that prior lease, which is why you have to withdraw it in writing. I hope you didn't send a signed copy. I've seen landlords do this, and it's not wise, where you sign the lease and you send it to them hoping they'll sign it and return it. Hopefully that hasn't been the case, but if you've done anything similar to that, and again, hopefully not, you can retract it if he still hasn't signed it. And so what you would say is, I offered you a lease previously, you're doing this in writing, that offer is hereby revoked. I am revoking that offer and am no longer offering that lease as stated. So because he hasn't gotten it back to you prior to that statement, that lease, even if signed, is no longer controlling. Well, let's assume, and hopefully it's the case, you did not sign that lease. You were waiting for the tenant to sign first. Do the same thing. Revoke that lease. You're going to revoke that offer. You're no longer interested in offering it. Instead, send a 30-day notice of rent increase, which essentially is that last lease that we signed, still in place. I love it. It's great. But I'm giving you notice that in 30 days, the rent's going to jump from X to 2X or 3X or 4X, whatever it's going to take to get him out. And so you say, look, I'm giving you notice of termination of all prior terms. However, if you elect, you can stay, but the new rent rate will be this new amount. So let me give you the practical way of carrying this out. And this is assuming that your lease allows a 30-day notice in this way. So you would send notice in January. Today is the 14th. And so you don't want it effective in February because the first of the month has already come and gone. Instead, you would say effective May 1st. If you stay, the new rent rate will be that big number. However, you are only obligated to stay through the month of February. If you do not elect to stay, please leave on or before February 28th, 2026. This way, you have ended effectively the prior lease. It has come to an end. I have no intention of renewing that agreement. However, if you do want to stay beginning March 1st, 2026, the new rent will be, again, massive number. If he stays and he pays it, well, maybe that's a good deal for you. If he doesn't, but he's still there, sue to evict him, right? Because he may come to you and offer, no, I'm not paying the new amount. You'll take this old amount and you're gonna, and that's it. I'm not paying anymore. Then you move forward with your notice to vacate. If that's his first delinquency, you send him a notice to vacate or pay. And if he doesn't pay the remaining balance, move forward with an eviction filing and get rid of this terrible, terrible tenant. But definitely you're going to want to revoke any prior offer you've made. Do it in writing, get it to him and say, hey, any prior lease that I've sent, those are proposals that I'm no longer interested in. Consider any offered lease hereby revoked. And then again, my stronger recommendation is make sure you send a notice of rent increase and make sure that if he's going to stay, he's going to pay max dollar for that. All right, well, it looks like that is it for all of our questions. I got nothing left in the chat. I do want to thank all of you for joining us. And like I said, you know, I'm coming to you every single week and, you know, bringing this live format. I enjoy the interaction with you, enjoy answering your questions. If, again, you would like to, you know, get ahead of schedule and submit your questions to me so that I can prepare for them and present them as I do every week. Don't hesitate to give us a call or shoot us an email to get on our mailing list, or don't hesitate to join us on Texas Landlords. If you own property in the state of Texas and want to be a member of Texas Landlords and are still not a member, you're missing out on a ton. We have over 8,000 members in that particular Facebook group that constantly share ideas and questions and recommendations for each other about landlording in the state of Texas. It's an excellent resource. You know, whenever we're asked legal questions, we'll give our answers and responses to questions there. But one of the things that we love doing is taking questions for our Wednesday live. That's one way to get on there. But otherwise, it's a great resource. And so until next time, I hope all of you have a wonderful week. I look forward to seeing you again. But again, until next time, happy leasing.